Now, Michael, obviously, we discussed your case with the CIA that you've submitted the FOIA request for. Do you have any updates on that at all?
With the CIA FOIA case, it was brought by Leslie James Pickering. He's the proprietor of Burning Books on Connecticut Street here in the city of Buffalo. And what happened was the case was assigned to Judge Villardo here in the Western District, and he just sat on the case for quite some time. And we didn't ask for it, but out of the clear blue sky, he punted the case to a judge in Vermont who issued a pretty strong opinion. He ordered the CIA to produce a document for in camera inspection, and the federal judges, as well as the state judges, because FOIL is modeled after the federal FOIA statute. So he orders the CIA to produce this one document, and the U.S. attorney, after the order was issued by the judge, the CIA contacted the U.S. attorney and said, "We don't want to comply with that order." So they filed a motion for reconsideration, and that's an extraordinary remedy. And the government even cited the incorrect federal rule as the basis for bringing this motion. So, needless to say, I opposed it. The judge, after reading my papers as well as the government's papers, went ahead and ordered the in-camera inspection. He didn't back down, and the CIA produced the one page. And then, as I was hoping I'd be wrong, but it wasn't. The judge reviewed the document in chambers and determined that it did not have to be disclosed. So he closed the case. I was denied attorney fees. No other records were produced, and that's the end of the CIA case. But we have another case involving Nate Buckley, who was co-owner of Burning Books. We had sued the FBI a number of years ago, and we were trying to get some informant information. The case is it's similar to the Kennedy assassination. Between Nate's file and Leslie Pickering's file, we're talking about thousands and thousands of pages of records. But the we Nate's file is much smaller than Leslie's file, so we did get some records, but other records were withheld. And one of the arguments I made is some of this information could not be withheld because the FBI's probe into Nate, into the bookstore, into Leslie was not a law enforcement investigation. It was really a political hit. It was if you look at the history of the FBI, its primary purpose is to monitor and quash domestic political dissent. So it's our position that these type of records are not covered by what they call the B7 exemption, which is the law enforcement exemption, and there's various subparts. There's one for an ongoing investigation. There's one for the names there's a personal privacy exemption under B7C. The B7D exemption covers confidential sources, and that's very broadly interpreted. That covers everything from traditional informants as well as banks and phone companies and so on. So anyway, I
So
made that argument.
my familiarity with FOIA would be when immigration perspective, the company I was working for would do a FOIA response request to the DHS for information on people that are trying to obtain immigration benefits so that we could see what their history was. And I don't really think there was too many issues when those response requests were sent out. Now there definitely was the redaction, so I know what you're talking about with the B7. A lot of times it might be like interviewing refugee officer, they withhold their name. That makes sense. But sometimes there would other documents would be redacted, and it would be okay. Why is that redacted? So that would be my only familiarity with that. I mean, do you think a lot of FOIA response requests are hard to get the information, generally speaking?
At the federal level, the biggest problem is the delay. Like Leslie Pickering's FBI FOIA case was filed on May Day 2014. It's still pending. It just had a birthday a few days ago. Happy birthday, Leslie's FOIA case. And Nate's case has been pending for a number of years. We filed it in the Western District in New York, here in Buffalo. We then went to the Second Circuit, which is in Manhattan, and we got handed our heads, and we thought, well, that's the end of the case. Unbeknownst to us, Stanford Law School has librarians who read these decisions around the country, and they try to find cases for their law clinic to take on. They're primarily interested in cases where there's conflicts in the circuits, where one circuit may rule one way and another goes the other way. So they were very intrigued by the Buckley case. So they decided to get involved. They flew Nate out to Stanford. They assigned 4 law students to the case, and they filed a petition for cert. And they also got, it's a libertarian organization
Now
called the
petition for cert. Sorry to interrupt, but you obviously are talking about there's circuits that are disputing. So obviously you mentioned you start at the district court level for the federal level, and then it can
correct.
go to the circuit for the
Yeah, the U.S.
appeal.
Court of Appeals, and the United States is broken into, there's what, 11 circuits, excluding the D.C. circuit. So New York, Connecticut, Vermont are in what they call the Second Circuit, and that court is based at 40 Foley Square in Manhattan. So after we got, as I like to say, handed our heads by the Second Circuit, we, typically most cases end there. So we got contacted by, or I got contacted by Stanford. They decided to take on the case. They flew Nate out to the law school. He met with the team working on the case. I participated by way of Zoom. So they filed a petition for cert with the United States Supreme Court, and that's based, and the Supreme Court, I think, gets anywhere from 8 to 10,000 petitions per year. And that's asking for permission to appeal. They're down to hearing less than 100 cases. I heard one of the justices mention that they hear roughly 75 cases, which is down from what they used to hear. So we filed the petition. In addition, Stanford was able to get Cato Institute, which is a libertarian um, group. I think they're based, well, the law firm that worked on the cases in Chicago, but they filed their friend of the court brief, and the Solicitor General is asked twice now for additional time to respond. But once they file a response, we have 2 weeks to file our reply to their response. And if all goes as planned, assuming there's no further delays, the Supreme Court may vote, tail end of June, whether or not to hear our petition. I'm cautiously optimistic because the circuit, there is a split in the circuit. So I'm hoping that they do hear it, and if they
Go to a vote?
indeed, yeah, go
Sorry,
ahead.
does this go to a vote? I thought that the Chief Justice kind of decides what gets brought up, or do they kind of
No,
hash it
no,
out informally sometimes anyways?
No, the justices, all 9 justices will take a vote to decide whether or not to hear the case. I believe you need, what, 4 votes in order for them to grant cert. And then if they grant cert, then the case will be fully briefed. We would file a brief, the government would file a response. And we're hoping the way the petition and the friend of the court brief is written is to appeal to because you have a right of center majority. We're hoping to get the attention of some of those justices. So I'm cautiously optimistic we may get this case heard. Like the Supreme Court, one of the arguments made, I believe it was in the Cato Institute brief, was that the Supreme Court hasn't heard a FOIA case in a number of years now.
Well, then he might be very right.
I sure hope so, but uh, I prefer just, there's a lot of parallels between FOIL and FOIA. I prefer writing letters, even though the emails are much easier. I've taken on a couple of cases at the state level where the requester made the requests and appeals by way of email. And it kind of gets messy going back and forth. And then, like I had one with the State Department of Health. I was trying to figure out what was going on, and then my client wasn't quite sure. So I'm old school. I prefer the letters, but I know at the federal level they want you to upload your request to these portals, and I've been trying to avoid that. And I think I'll be able to, given my age. But we'll let the young whippersnappers use emails and portals and that type of thing. But Paul's right. Uh, Even if, like, I've brought innumerable cases at the federal level and I've brought a number at the state level. Even if you have a history, and Paul's been involved in this stuff for a while, you would think, not that they should, but you would think if they say, well, Paul Wolf's made a request or Kuzma's involved, you would think they would at least respond or produce some of the records. And we get the same runaround as the novice. And they know most people aren't going to bring a lawsuit. There's very few attorneys in this area who will take on a FOIA or FOIL matter. So, I in this recent case I had against the health department, I even contacted the FOIL person, and I said, "Look, we'd like to avoid litigation." When this was non-controversial stuff, and the guy just ignored me. It was like I didn't exist. So they stonewall people, and they know 98% of the time people will just walk away. They'll give up. And I don't see, and the courts, a lot of the courts don't know much about FOIL. I helped they, or I gave, I have sample requests and petitions online. So a gentleman filed a FOIL case here in Supreme Court, and he tried to get his litigation costs, and he couldn't get his attorney fees because years ago I tried to get pro se attorney fees long before I became an attorney. But they said, oh, Article 78 doesn't provide for attorney fees. And I said, wait a minute, you're trying to get fees under FOIL, not Article 78. And now both the court and the city of Buffalo are just blowing this guy off. So they make things incredibly difficult.